So in the last lesson, we talked about trial courts and we talked about the two sides. The defendant is the person on trial, and then you have the plaintiff in a civil case who's bringing the charges, or you have the prosecutor in a criminal case who's bringing the charges. And then we mentioned appeals courts. We're going to talk about appeals courts more in the next lesson. And then we talked about juries and all the qualifications for a jury member, and gave you a little background. That is a constitutionally protected right, thanks to the Sixth and Seventh Amendments. Okay, um, so we kind of gave the background to trials. Today, what we're looking at are the steps in a trial. All right, and you do have to get all of these down. All right, be sure you get all of these down. So, this is what happens in a trial, whether it's a civil trial or a criminal trial. The first step is the opening statement is made by the plaintiff or the prosecutor. They explain the evidence to be presented as proof of the allegations, okay, unproven statements, all right? So they give an overview of what they are going to try to prove, what crimes have been committed, et cetera, okay, and what they are going to show in the case. Now, they get to go first because they have the burden of proof. They are bringing the charges against the defendant. And remember this idea that we have in our country: you are innocent until proven guilty. Okay, the burden of proof rests in the plaintiff and the prosecutor, so they get to go first. Now, after they make their statement, there's an opening statement by the defense. Okay, they're going to explain their side of things. They're going to explain how their evidence is going to show the defendant is innocent, and how their evidence is going to show that the charges made by the plaintiff or the prosecutor are untrue. Okay, how they're going to disprove the allegations against their client. All right. So after these opening statements, plaintiff, prosecutor goes first, then the defense, then the plaintiff will bring their case. All right. You have direct examination. They bring all their witnesses, they bring all their evidence. Okay. They get to go first. And again, the reason is because they have the burden of proof. All right. Now, while there is direct examination of plaintiff and prosecutor, at the same time, there's cross examination by the defense. Okay, so the plaintiff and prosecutor bring all their evidence first. They're going first, they're questioning their witnesses, they're explaining their evidence, but at the same time, the defense attorney is also cross-examining, okay, and trying to disprove the allegations brought by the plaintiff and the prosecution. Right? Now, if the plaintiff or prosecutor does such a good job that there is no reason to go on, the fifth step in the trial are motions. Okay, if the plaintiff or prosecutor has established their case beyond a reasonable doubt or with preponderance of the evidence, the judge can end the case by granting a motion. It's an oral request made by the defendant's attorney. The defendant just says, "Look, there's no way I can compete. There's just too much evidence against me," and the judge can issue a motion, and then boom, we go to the jury, and we're at the end of the trial. Very rarely happens, okay, because the defendant really wants his chance to disprove the allegations of the prosecutor, the plaintiff. So if there are no motions, we pick up with the defendant's side. Okay, now the prosecution and the plaintiff have gone first. There's been cross-examination by the defense. Now it's the defense side. They're going to present all their evidence. They're going to bring forth their witnesses. They get to lead the questioning, et cetera, et cetera. While they're going on, then we get cross-examination by the plaintiff and the prosecutor. Okay? So you have opening statement by plaintiff and prosecutor, opening statement by defense. Then the plaintiff prosecutor gets to go and present their case. If they do such a good job, and while they're doing that, there's cross-examination by the defense. If they do such a good job, the judge will issue a motion and we'll move to the verdict. Very rarely happens, which means the defendant gets to go present all their evidence, all their witnesses. While that's going on, we get cross-examination by the plaintiff and prosecutor. Okay. Now I just review that to say after this, then we start moving to the final stages. Okay. You will have a closing statement by the plaintiff or prosecutor. It is a summary. It reviews the evidence that they have presented. and ask for a finding of guilt or a finding for the plaintiff. Guilty in a criminal case, finding for the plaintiff in a civil case. Okay? And they will not only summarize their evidence, but they will also, once again, summarize the evidence presented by the defense and explain why it is not good. Okay? Then, after they make their statement, the defense gets to make its closing statement. And of course, they're going to do the same thing. They're going to summarize their case. They're going to summarize why the prosecutor or the plaintiff didn't do a good job. And they are then going to ask that you find the defendant not guilty in criminal cases or find in favor of the defendant in civil cases. Okay. So again, they're going to summarize their take on things and then ask for a verdict. All right. After that, okay, again, because the burden of proof is on the prosecutor, there is a rebuttal argument where the prosecutor and plaintiff can respond to the defense. Okay, it's one last time for them before the jury is turned loose to explain their case and explain why there should be a guilty verdict. Then, after all this, the judge will instruct the jury about the laws that apply to the case, about what implications are in their verdict. For example, if it's a criminal case where the death penalty is considered, the judge will let the jury know that, okay? That if you find the defendant guilty, it is very, very possible that they could be sentenced to death. Okay, so the judge gives the jury instructions, and then the jury goes into quarters and they debate the case. Okay, then they will come back with a verdict. Now, in criminal cases, it has to be unanimous. All right, in civil cases, it does not. But in criminal cases, it has to be unanimous. If the jury cannot reach a unanimous decision, it's considered a hung jury. The case could be tried again with a new judge or jury, or depending on how serious it is, depending on if this is the second or third time that there's been a hung jury, the case could also just simply get thrown out. Okay? So we've got instruction by the judge, then the jury is dismissed to bring back a verdict. Okay? And that's it. All right. After that verdict is given, then it turns, if the verdict is guilty, then it rests in the hands of the judge to determine punishment. Okay. And what is going to happen there. All right. So, real quickly and brief, prosecution opening statement is first, defense opening statement is next. Prosecution presents its whole case with cross-examination by the defense. If the prosecution does such a good job, the judge will issue a motion to end the trial. Based on recommendation from the defense. Usually this is not going to happen because the defense wants to be heard, so we will hear all the defense arguments while there's cross-examination by the prosecution. Then there's closing statement by the prosecution, closing statement by the defense, one last chance for the prosecution to make a rebuttal. Then the judge issues jury instructions. The jury goes into quarters to come up with a decision, and that decision is the verdict. And that ends the trial. And then, of course, after the verdict comes the punishment, but the judge hands out the punishment, not the jury. So those in brief are the steps of the trial. Okay, so we talked about what a trial is. We've looked at the cases or the sides. We've talked about the steps of a trial. Now, let's say you are unhappy with the verdict that is handed down in your trial. Can you appeal? Yes. And that's what we're going to be talking about next in our next lesson, are appeals courts and other types of courts in this trial court system.